talk about communications with the carrier or plan about VA benefits and unemployment decisions. So the question becomes that I get as a VA and Social Security and ERISA disability attorney is, do I have to send the disability plan or policy my VA rating or TDIU decisions? Now, there are two considerations at play in answering this question. The first is one that's unique to you based on the policy or the plan. So is there a provision in the policy or plan that requires you to cooperate with the carrier or the plan? And secondly, is there an offset provision or other income provision that allows the carrier or plan to reduce your benefits by the receipt of VA benefits or that you might be getting? And of course, the question is, were you getting them before or after this claim? So let's talk about the duty to cooperate. You have a duty to cooperate with the carrier or plan, and failing or refusing to give the carrier or plan a copy of your VA decisions can be a breach of the policy. And that means that they can deny your policy benefits or terminate your benefits because you didn't cooperate, regardless of how disabled you might be. And that stinks, but the court will uphold a claims denial or termination of benefits based on a breach of your duty to cooperate. Let's talk about the offset provision. Now, this is much more problematic. Some policies or plans don't have an offset for VA benefits, and that's great. Others prohibit any offset for the VA benefits that you might be getting at the time you became disabled, but allow an offset for any increase in benefits that you get. I mean, it could be an increase in the impairment rating. It could be a TDIU award. So the carrier or plan might be able to claim an offset for those additional benefits. There are some policies or plans that allow for an offset for any VA benefits that you were getting at the time you became disabled under the times of your policy. And it doesn't matter if the medical conditions that you were getting your VA benefits are different and have nothing to do with the medical conditions that are the basis of your disability insurance claim. I will tell you that different federal circuits around the United States have taken different approaches to the offset in that situation. And it's really going to depend on where you live and what circuit law is applicable. And certainly if that's the situation, you need to be consulting with an experienced ERISA disability attorney. How about unemployment benefits? Now, while the disability carrier was fooling around deciding your claim, you may have applied for unemployment to keep the money coming in. What's your legal obligation to tell the carrier about that? And again, they're the same two considerations. Is there that policy provision that you have the duty to cooperate? And is there an offset provision that allows the carrier to reduce your benefits by the receipt of unemployment? Again, if there's a duty to cooperate and they ask you for a copy of your unemployment application, the decision, your job search, a copy of your checks, and you don't give it, I think that that could be a breach of the policy or plan. They may even ask you to sign a release that lets them contact your state unemployment office to get unemployment information. And if you fail to do that, that could be a breach of your duty to cooperate. That means that they can deny your claim or terminate your benefits because you didn't cooperate, regardless of how disabled you might be. Again, that stinks, but the courts are going to uphold a claims denial or termination. How about the offset provision? Is there an offset in your policy or plan for the receipt of unemployment benefits? That means there might be a dollar for dollar reduction of your benefits. Every dollar of unemployment benefits will reduce the amount of your long-term benefits. And what are they likely to do with that rather favorable decision? What they're going to say is, look, this is inconsistent. You're claiming on the one hand that you're disabled, but on the other hand, you're claiming that you can work, and that's the basis of your unemployment claim. So which is it? And we're going to presume that you're capable of working because you're certifying that you are capable of working when you file for unemployment. So we're going to deny or terminate your benefits, as stinky as that might be. Now, sometimes you might be getting state disability benefits, and there are certain states that provide state benefits, like New York, New Jersey, California. There's a state disability system that pays these benefits for a period of time if you become disabled and unable to work. So can you collect both? And what's your legal obligation to tell the carrier that you might be getting both? Again, it goes back to the same thing we've talked about. Is there a provision or in the policy or plan that requires you to cooperate and disclose that information? And is there an offset provision in either the short or the long-term disability policy or plan that would allow them to reduce your benefits by whatever you got in terms of state disability benefits? So I will tell you that many times I see in the other income provisions of disability policies or plans, that laundry list of other income sources. Unemployment is on that list. Social Security can be on that list. VA benefits could be on the list. And there can be unemployment benefits. If your policy or plan has those provisions, there is an offset provision. And if you don't address it, if you hide it, ultimately they can come back and say, look, we've overpaid you benefits. We're going to sue you unless you pay us back. And by the way, we'll reduce any future benefits by the receipt of this overpayment. So obviously you need to understand this interaction between other income benefits when you're applying for benefits, and certainly when you get a favorable or unfavorable decision.